Blankenship here, Divorce661.com, Daily Perspective, episode 55. It's been a minute since we've done the Daily Perspective. At least a couple of days have gone by. Got quite busy, so I apologize. This is the daily podcast where I go over what we've done, issues clients have had, why they hired me, how we fixed them. And so you can learn if you're trying to do your own divorce. Maybe you're an LDA, maybe you're a paralegal doing this on the side. And yeah, you're just looking for some help. A lot of our clients find this information helpful. They're trying to do their own divorce, and then maybe they eventually just call me to take care of it. Either way, I'd be happy to help you. So I want to start this initial recap here with a little bit of introduction because people always ask, who are you and why are you talking about this stuff? I'm a legal document assistant. I've been doing this for 12 years, specializing in amicable divorce cases anywhere in California, handling 40 plus divorce cases a month on average. And I've now at 3,300 videos on YouTube plus and over 3 million views on YouTube. So I like to think I know what I'm talking about at this point. Recap for the year so far. So we're just ended February 2024, 43 new divorce cases for February, had about the same for January. So we're at 85 divorce cases so far for the year. And this month in February, we handled divorce cases for the following counties: Madera, LA County, Riverside, San Francisco, San Diego, and San Bernardino, San Mateo, Ventura, Contra Costa, Santa Clara, Riverside, Alameda, Madera, Monterey, Merced, Orange, Sacramento, Santa Barbara, Santa Cruz, Solano, and Tulare. So why do I say that? 85 divorce cases so far, 43 were this month in February, and all of those counties were handled just in February alone. And I bring that up so when people ask me, Tim, do you specialize in divorce in my county? The answer is yes. We work with all the counties in California. The process is nearly identical. Some counties have slightly different forms, if you will, procedures, but pretty much the process is the same. But because we file so many cases in California and the various courts, we know what those little nuances are. So now I'm going to go over what we did today. 7 judgments were prepped, finalized 5 cases, submitted for court review, and we had 3 already approved by the court. 2 people that hired me today, I already completed their paperwork. One was a 2019 divorce case. The other one was a 2021 divorce case that they've been struggling on getting their paperwork through the court. Hired me same day. It's prepared. They e-signed it, and I've already e-filed it with the court. So let's get into some of the issues clients had and why they called me in cases I took over for them. 2021 LA County divorce case was finalized. This is the 2021 divorce case. I'm just looking at my notes. They had been working on the divorce case with multiple rejections. It's very common that there'll be multiple rejections, not just one rejection. Turn your judgment gets rejected. They tell you what's wrong with it. You fix it, comes back for different issues. And I've talked about that a lot, and you guys know what I'm talking about there. There are so many reasons this judgment was being rejected from the very beginning, from the proof of service being prepared wrong, which was causing the request to enter default to get rejected 6 times. Can you imagine the same document getting rejected 6 times? And after 5 years of struggling on their own, they asked me to take over their case. I was able to review and finalize all their paperwork the same day they hired me and e-file with the court. One thing I want to bring up with that, and was why I like going over these cases with you, is one form, proof of service, was causing everything behind it to reject. If one document is wrong in your initial filing, whether it be the summons, the petition, the names not matching, you're not addressing spouse support or property in the petition, or any little error, even though the court has filed your documents, they're not reviewing it until you submit the judgment, and that's where everything unfolds. And in this case, it was the proof of service that was, if you will, knocking down all the rest of the pins for the divorce. The judgment was never going to go through until the proof of service was corrected, then would allow the request enter default to get entered, then would allow the judgment to get approved once we corrected all those issues. So point of that story is you need to make sure everything is correct from the very beginning. When people hire me to take over their case, like these 2019 cases, 2021 cases, doesn't matter. Whatever they filed, I have to review all that. I can't just take over and say, great, where are you at? You've already done this. Let me assume that's correct and draft your settlement agreement and submit it. Why would I not want to do that? Because it's just going to get rejected if I don't review all the prior paperwork. Even if you haven't got a reject from the court yet, like your judgment hasn't been submitted once or 6 times in this case and it's been rejected, or you get that reject letter, I still want to go through and review all your paperwork to make sure that's correct, because if I don't do that and there's an error, it's going to get rejected on me too, and that's not what I want to do. And when you do have the reject letter, I don't also just fix what the reject items are, because again, the courts will only go through and look at a couple of things, reject it for 3 or 4 issues. Maybe there's 20, but they'll stop, do the reject letter, kick it back to you, you fix them, turn it in, reject it again. So I also don't just fix what they say is wrong with it, because there's usually a lot more wrong with it. Next case was a 2023 Merced Divorce Case. Clients filed and served, but then got stuck on how to finalize the divorce and made no progress. So they're only a year into this. I say only a year when we get our cases done in 5 weeks, but a year's a long time, folks, to let your divorce go through without getting it finalized. But yeah, 2023 Merced Divorce Case, filed and served, then got stuck on how to finalize the settlement agreement. Hired me to take over and finalize remaining paperwork so they could sign and so we could submit to court. This is generally where people will get stuck. I'd say half the clients that call me started their divorce already and they got stuck. And where they get stuck is right about here. They do the initial summons petition. That looks like it's pretty straightforward. Maybe they've served the paperwork. Maybe they've even done the disclosures and what needs to be done next, or you tried and you got stuck and then you just put it to the side, because I get it. Divorce is the last thing you want to do at the end of your day. And that's why I'm here to help you with that process. I know exactly what it takes to get it done. I get them done quickly. So if you're considering or kicking it around, should I hire Tim? If you have the money, I definitely recommend it. We'll get your divorce done so you can literally put this behind you. All right, so I have some notes here. Don't put off starting your divorce. I had a Monterey County clients had been separated since 2019, never got around to filing for divorce. They hired me to handle their divorce case, and we were able to get same-day filing on their case, which is nice because a lot of the counties are coming online, so we can at least file the initial petition, and we were able to file the settlement agreement the very next day, and we'll be sitting down to sign all their paperwork this week. So if you guys, so this was new clients, they just had not ever filed anything. So it'd been a couple of years since they separated, and it happens a lot. We have cases 25, 30 years of separation. They just never did the divorce, and no issues, except if you don't know where your spouse is, that would be an issue. But where you know your spouse and you guys are cooperative, it doesn't make it any more difficult for us to finalize those. But with Monterey, if you guys come, or I shouldn't say Monterey, with any county, if you guys are amicable, and with the counties we can e-file, which a lot of them are coming online now, and we get those same day filings. Once I have that case number and you've provided me your terms, whatever that might be, who's keeping what you're doing with the kids, if there's any support, etc., I can finalize the remaining of your paperwork. I don't have to drag this over months or years or even the 6 months. I get everything. I crush the entire 6-month process into a couple of days, a week, just depending on when you get that information to me. And we can get you wrapped up. So for the clients that are everywhere other than, say, 3 counties that allow the entire process to be e-filed, meaning the judgment package, you guys have to print, mail in, sign original signatures, go to a notary, and then mail your judgment paperwork into me so I can make all the copies, kill all the trees, and submit to court. We can do that like on day 3 or day 4. We will just post date a lot of the documents because everything is based off the date of filing to then the date of service. And then when we can submit to court, all flows off of that file date and serve date. So I can post date all your documents. Certain documents have to be filed at a certain time. Like for instance, the request in or default has to be at least 31 days after the date of service. So if we file on a Monday and Tuesday is the date of service, 31 days after that day. So let's say it's like March 4th and you were served today, and we don't serve you personally. It's just a form that you sign called a notice and acknowledgement. Then the soonest we can submit your paperwork for review to the court is going to be March 5th, 31 days. So March 5th, April 5th, the following month, 31 days later. And so I'll post date those on there. 1, so you know when I can submit your paperwork to court, and 2, so you don't accidentally date that prior to, since you're signing everything well before the 6 months, well before the 31 days. So I want to post date that so you don't sign a date that we can't use. All right. Next subject, 2023 San Mateo divorce case. They didn't know how to finalize their divorce because they didn't want to sell the home until the end of 2024. and they wanted to live together. So they thought they had to wait until it was sold. Obviously, that is not the case. We simply state in the agreement how that's going to be addressed. So, did you just to kind of go over that again? They had filed for divorce, but they weren't finalizing it because they were still living in the home together and they weren't going to sell it for a few more months. So they thought, we can't finalize a divorce until the home is sold, and then we will finalize the divorce. And, because the house is sold and everything's been divided up how they wanted. So what I told them, I said, no, we don't have to wait. We're simply going to state whatever it is that you guys are trying to do. So what they want to do is stay in the home, and then at the end of the year, sell the house and split the proceeds evenly. So that's all we said. So instead of delaying them being able to finalize their divorce like they thought they had to until the home was sold, we simply stated in the settlement agreement that they're going to continue living in the home, share the mortgage, and then sell the home, at the desired time at the end of the year, and split the proceeds. Finalize their paperwork. They signed it. We submitted it to court. That's simple. There's no reason to delay your divorce case because of terms, house, pensions. You can even put, let's say you're not sure, Tim, we don't know if we're going to sell the house and split the proceeds, or I'm going to buy my spouse out. So we're going to wait to do the settlement agreement. No, you don't have to do that. We'll just put both options in the terms. If the desired action is that you want to buy out your spouse, and then if you're unable to do that, then sell it. That's exactly what we'll say. Very simply in plain English, petitioner tends to buy out the respondent for X amount of dollars by a certain time. If for some reason they're unable to qualify or refinance or get the amount of money that they need to buy out their spouse for, the end result will be they will agree to sell and split the proceeds at that point. We can put any variation of options in there that gives you guys the different options you guys want to be able to finalize your divorce now and handle any different eventualities that might come up down the line. And keep in mind, let's say that we didn't include that. Let's say that we finalized your divorce and said the house is going to be sold and the proceeds split evenly, and the divorce gets finalized and the judge, you guys sign it, judge signs it, you're done, and the divorce is over. And then you're like, oh shoot, Tim, we changed our mind. I'm actually going to buy my spouse out. We need to modify the judgment. You really do not need to modify the judgment. You guys have an agreement now. The judgment went through that you're going to sell the house and split the proceeds, but now you're going to buy out your spouse. And it happens. People call and say, what do we need to do? I'll say nothing. We don't. Just buy out your spouse. You guys agreed to it. Doesn't mean we need to formally change that in the agreement that it'll be sold. You do the buyout, however much it is. We don't need to document that, not for escrow, not for your mortgage, not for any of that. They're not going to need a copy of that. You're simply going to either, refinance the house, get the money from your parents or whatever you're doing to buy your spouse out. Do the quit claim, take them off title. None of that requires it to be updated in the settlement agreement. Next subject, 2024 Riverside divorce case. They filed and then they had no idea what happens next, and no progress was made for 2 months. Are you seeing the overarching theme here? People file and then they get stuck and then they just put it aside. Months and years go by before they take any action. Again, this is usually where people reach out for help, is what my notes say. They had quite an extensive agreement, including 2 homes, pension division, and spousal support needs. So this is definitely something they should not be handling on their own. I prepared the final paperwork and settlement agreement, and now they're signing and file with the court. So this was a case from last week, and they had a lot of things involved. They have multiple homes, rental properties. They wanted a little bit of spouse support included. They were also going to continue living in one of the homes for a period of time, and they had a lot of different terms and agreements they wanted included, and they're trying to do their divorce on their own. And like I said, they had filed. It was a more recent case. It was filed in 2024, but it just nothing. They filed. That was it. No one was served. They were progress in that they were discussing the terms, and they were trying to get that down on paper. But for them to do that properly in an official marital settlement agreement with all the little pieces of information they wanted included in there, they were definitely going to need my assistance in getting that through the court, just to make sure it's documented correctly. All right, next subject, settlement agreement is where most people struggle, kind of going back to what we were just talking about. That's where they will either have some type of written document that maybe it's a Google Doc or a Word doc that they'll come up with. The worst thing you can do is finding a a template on Google that are terrible, that the courts don't accept, that will cause all kinds of rejections, have all kinds of unnecessary legalese and boilerplate you don't need, that's unrelated to California divorce. They'll cause your judgment to get rejected. And then it's also missing pertinent legalese, especially when it comes to legal requirements, language for the kids and custody and all that. It's going to send you off. And I'll see a lot of those. Since I've been doing this for 12 years, I'll still see these templated settlement agreements that I can tell got it from Google, and then try to fill in their information where the blanks were. In this case, going back to the settlement agreement, they don't know what needed, what language is required, will be suitable with the court. And one of the biggest issues they have concerns with in drafting the settlement agreement, even if they knew how to do it correctly, is will the judge approve the terms they want? So I want to tackle two things here. Number one, the term, what will a judge say? And two, the language that goes into the settlement agreement and needing to know what kind of information goes in there. And what people will miss is the specifics. So at the end of the day, when it comes to, say, assets and debts, it's going to be a list of property that each of you are keeping, identifying it, name of the asset, last four digits of the account number, not needing to list values. There's a certain way it needs to be done for the court to accept it. So that's where people get stuck on the settlement agreement. The other reason they get stuck is because they're afraid, based on their terms being unequal, that the judge will say, no, we don't agree to this. It needs to be divided equally. And again, that's also not the case. If you do a stipulated judgment, that's a fancy word for an agreement that you guys sign and notarize, the court's not going to get involved and say this doesn't seem fair. And what I tell folks on my consultations is, generally speaking, the court's not going to know if it's fair or not, because we're just listing assets by name and account number, not by value. And these folks, they had 401ks and pensions and the whole thing, and they were saying, hey, do we need, the assumption is we need to list the values to the court. No, for the settlement agreement, you don't need to list assets and debts valuations, unless it's like a specific amount going to someone. If it's 50-50, just say 50-50. If it's 80-20 for whatever, just use the percentages. But if it's going to be a specific dollar amount, because like in this case, I want to say one spouse was going to get $10,000 from the 401k, then we have to call out the 10,000. But if it was going to be their community property share, we would simply say that they're going to receive their community property share, which essentially is from the date of marriage to date of separation. The court knows that, the plan knows that when it comes to dividing that up. So do not worry what the court or judge will say about your agreement. It's not going to be an issue. Next subject. We just finished a settlement agreement for clients, and don't forget the pets and intellectual property should also be listed. We had clients that were in the movie industry, and they had scripts and other intellectual property. So in their settlement agreement, that was really the totality. I want to say it was a short-term marriage. There was no alimony, no real physical assets and debts, cars and bank accounts and so forth, but no home and things like that. But they were concerned about the intellectual property and their pets. So while we aren't normally listing the pets in the settlement agreement, it rarely comes up. And I know a lot of people have pets. It's just not an issue. They've discussed who's keeping the cat or the dog or the parrot or what have you. But sometimes we are listing. In this case, they wanted to list the pet, and not a problem. Who's going to care for the pet? You can get very specific. We've probably a couple of years ago, there was 2 dogs, and I wrote up a custody schedule. Very simple one. They'll be shared custody of the dogs, and they'll when they'll be at each other's house and who will drop them off. Kind of treat them like kids. To some folks, if you're a dog lover like my family is, the dog would definitely probably be the one thing we would fight about. Not the money or anything else, just probably the dog, because it can be an issue. But yeah, don't forget the pets. And then intellectual property. We did a kind of a boilerplate statement to say that each party to keep 100% of their respective intellectual property. You don't have to get into detail unless there's actual scripts or artwork, or in this case, there was an active script being worked on, so that, the intellectual property is community property as well. If it was, an asset per se, it turns into, something that's viable financially in the future, definitely would want to call those out and list those out. I want to say like 4 or 5 years ago, we had a significant settlement agreement that we put together that listed 30 or 40 different pieces of intellectual property, um, names of potential movies and script titles, for the shows or the movie, scripts in general, an idea about a mascot, or the person who came up with the Geico Gecko, for instance. Like they had ideas. So in this case, so you can get specific if there are these specific intellectual property items there to list. You can list them. In this case, there was one asset, one script that we listed, and aside from that, we used the boilerplate to say, any and all intellectual property thoughts, was the 100% being owned by the party who originated it, something like that. I forget exactly what we wrote, but I came up with something that satisfied them and the court. So pets and intellectual property, you can list those as well. And we do have a lot of clients in the movie industry, not so much the artist side of things, a couple actors, actresses, script writers, but more in the trades. I would say lighting, painters, that sort of thing. People, the grips, those folks, we get a lot of movie industry people, and they have the pensions and the MPI, the motion picture industry, 401ks and whatnot. So we deal a lot with the movie industry in that way as well. Next subject had a new case. They're separated since 2001 and never filed for divorce. I think I mentioned that earlier. And people ask, Tim, does it make the divorce process any more difficult if we've been separated for a long time? The answer is no. The only thing that could come up is if your spouse had passed away, you don't no longer know where they live, you can't reach out to them, and that will make your divorce nearly impossible. It'll get done eventually, but I mean, it could probably take a year or longer. But it's always going to be easier to find your spouse, assuming they're alive, than trying to do the service by publication and all that nonsense, especially if there's like minor children or pensions and all that. You're going to want to have this drafted as a settlement agreement that's stipulated, signed and notarized by the parties, or you're going to have problems down the line. 2019 divorce case, no assets or debts, just wanted an agreement for spouse support. We're stuck in the process. Filed a response unnecessarily, and they were about to go to trial for no reason. I just got that approved. I keep looking up my screen. With LA County, everything's e-filed, and so we'll get notifications of cases that we submit. We get an email notification confirmation of filing when it's accepted, approved, and then when it's actually approved and signed by the judge, we'll get another notification. I just see them popping up. So we prepared this for them, and they had signed it, and we filed it today, and it got approved today. So congratulations, your divorce is approved. I'll be sending you, I know you don't know who I'm talking to, but I'll be sending them their approval, which they'd been working on since 2019. And the reason I wanted to bring this particular case up is they were doing their best trying to do it on their own. And I want to give you a parallel to what would have happened if they would have hired me from the get-go. So what happened was, wife filed 2019, served her spouse, process server, sheriff, unnecessary. We can have you sign a notice of acknowledgement. Super simple. There was no real assets or debts. There was a truck and some vehicles, no pensions or homes or anything like that. So overall, very straightforward. However, wife did want some alimony for a period of time. I want to say it was like for 5 years. They were married 15, but they agreed to support for 5. So they didn't find me. Obviously, they didn't use my service at the time in 2019. So they didn't know that you can just incorporate the spouse support agreement into the overall settlement of your judgment. So what she did was filed a motion called a request for order. This is the FL-300, and asked for a hearing so the judge could order spouse support. And they went to this hearing, and spouse support was ordered, and he agreed to pay spouse support. It wasn't like they were like she wanted it and he didn't pay it, but this hearing was completely unnecessary. The reason they did that because they didn't know any better to have a service, say like mine. If they said, "Hey Tim, we agree to spouse support, but we don't know how much," simple. I can run the numbers just like the court can, and we say, well, based on the incomes, here was the amount of support. It was like, I forget what it was. It doesn't matter, but they agreed to it. So in 2020, they had a spousal support order ordered by the judge, and he's been paying it all these years. but their divorce was still pending, because even though you go to court on a hearing, like to get temporary orders, like in this case, they wanted spouse support, you still have to finalize the divorce case. So they didn't know that. And there were some other issues. She tried to file the default because, that's what the court tells you to do next. Meanwhile, he's filing a response because that's what they're telling him to do next. That the paperwork got all messed up and they weren't communicating. All he knew is he's paying the money per month for support. And they just, 3 years go by, there was no activity because they just got, frustrated. Called me up. We took care of it. I saw they had the hearing, explained to them, hey, this wasn't necessary. All you had to do is, I know not everyone can find me, but we could just ran some numbers. Here's the number. You agree to that? Great. Put the spouse support in the numbers. We still had to incorporate that into the final agreement. So that temporary order they had from that hearing, we had to carry that over into their final settlement agreement to state that they're keeping, the spouse support is going to be X amount. And I think there's like 2 years left out of the 5. They've been paying for 3. So we just said spouse support will be paid from whatever date this order originated until 2025 or whatever it was, the final payment date. And keep in mind also, if you have an order from court, you cannot attach, generally speaking, the order you already have from the court. You have to put it into the actual order of the settlement agreement for your actual divorce. So they had an order for temporary order for spouse support. We had to put that into a formal order as the FL 343 spouse support attachment to their judgment package. All right. I hope you enjoyed this episode of the Daily Perspective, episode 55. I want to let you guys know also, if you're still with me, I'm going to be doing bigger deep dive discussions, 10, 15 minutes on a single topic. I've noticed that those videos are getting a lot more traction than, say, the 2 to 3 minute videos where I cover a single topic kind of high level, or even my little 15 to 60-second short videos, which are just kind of attention grabbers, little bits of information. I did a video about the truths of child support. It was maybe 10 minutes long, and it got 10 times the views of my normal videos. So I'm going to be doing more of these deep dive type subjects. I'll be recording later today one on no fault divorce and what that means and how that affects you and your divorce and so forth. I'll be going into detail. It'll probably end up being a good 10 or 15-minute video. I cover a lot of good topics. So I'll be doing that as well. And we will talk to you tomorrow in episode 56 of the Daily Perspective. Have a great day.